I get to mention item number 2. Lordship.
Yes.
After 2 weeks, anything.
Yes, MS Bora,
Lordship.
on the prayer of Mr. L.R. Muzumdar, Learned Counsel for the appellant. Release the appeal after 2 weeks. MS S.H. Bora, Learned Additional Public Prosecutor for the respondent state, is present.
All right.
Please, Your Lordship, my lord, with respect to item 6, may it be taken up immediately after the part third item, because this is also
Okay.
part third.
My lord, I beg to mention a criminal appeal, my lord, for orders, my lord, any date, my lord. Deeply authorized.
May I please, Your Lordship? Lordship, I beg to mention item number 3.
Hmm.
The learned amicus curiae is busy attending his wife, who is hospitalized at GMCH.
Mr.
PJ Bora.
P.J. Bora, Learned Counsel, appearing for Mr. B. Prasad, Learned Amicus Curiae, for the appellant, has submitted that Mr. Prasad has some domestic health issues and is not in a position to appear in the court today. Mr. Bora has just paid for listing of the appeal after 2 weeks.
After 2 weeks.
MS, considering the ground cited, there is no objection from the learned additional MS Bora, learned additional public prosecutor for the respondent state. So establish the appeal. Very loud, list the appeal after 2 weeks.
Lordship, he has another 2 meter for tomorrow. I have
Particularly mention memo.
already submitted. Obliged.
May I please, Your Lordship? I beg to mention item number 8, due to, yes, due to personal difficulty of my senior BM Chaudhary,
B.N. Chaudhary, okay. Miss
Upasna Sharma. Upasna Sharma.
U. Sharma, learned counsel for the learned counsel appearing for Mr. B.M. Chaudhary, learned counsel for the appellant, has paid for listing of the appeal after
Some other day.
22, 3 weeks, 1 year, 3 weeks. Stop. It is permitted and consent has been taken from the learned counsel for the respondents to make the prayer.
Obliged.
May it please, Your Lordship. Lordship, I beg to mention a criminal bail application, Your Lordship.
Louder.
A criminal bail application, Your Lordship, under section 21 of NI Act to be listed on Friday, Your Lordship.
When?
On Friday, Your Lordship.
On Friday, already fixed. Next week.
I beg to mention item number 1,
Yes.
and my humble prayer is to adjourn the matter for today and kindly fix after
Your name, please.
B. Borua.
B. Borua.
Yes.
You are appearing for whom?
S. Borgohain.
Mrs. or Mr.?
Mr.
Okay. MS S. Borua.
B. Borua.
B. Borua, learned counsel. Appearing on behalf of Mr. S. Buraguhai. Buraguhai or Boruguhai?
Borgohain. S.
Boruguhai. দুটা আছে না? Learned counsel for the appellant. Has paid for adjournment of the appeal for 2 weeks. MS S.H. Bora, learned additional public prosecutor for the respondent state is in attendance. The prayer made on behalf of the appellant is allowed. Leave the case appeal after 2 weeks on a day 2 weeks by the office.
Obliged.
এই দেখা আছিল নি দেখা ও দেখা লাষ্টৰ খিনি কি আছে from the postmortem examination report, EXT4, it is evident that there were multiple penetrating wounds on the right side scalp. No, wounds of breath, 1 inch size on the right side scalp, right side, right upper neck, right front chest, right shoulder and left shoulder. Full stop. The vessels were severed at different levels. The pleura was ruptured. Full stop. The temporal bone of the skull was found fractured. Full stop. By the postmortem examination report, and from the opinions of the autopsy doctor, PW12, it is demonstrated that the injuries sustained inflicted on the deceased were done with the intention of causing bodily injury to the deceased, which was sufficient in the ordinary course of nature to cause death. Full stop. Paragraph. এই বুদ্ধি সিংটো আপুনি বুদ্ধি সিং in the Honorable Supreme Court of India in State of Andhra Pradesh versus Raya Bharapu Punaiya and another, reported in 1976 for SSC 382, has explained about the manner to proceed to decide the question whether the offense is murder or culpable homicide not amounting to murder, on the facts of the case. Full stop. It has been observed that the issue is to be, the problem is to be approached in 3 stages. Full stop. The question to be considered, it will paragraph 21 of the 21 of Shiloh. The question to be considered at the first stage would be, whether the accused has done an act by doing which he has caused the death of another. Full stop. Proof of such causal connection between the act of the accused and the death, leads to the second stage for considering whether that act of the accused amounts to culpable homicide as defined in section 299 of the Penal Code. Full stop. If the answer to this question is prima facie found in the affirmative, the stage for considering the operation of section 300, Penal Code, is reached. This is the stage at which the court should determine whether the facts proved by the prosecution bring the case within the ambit of any of the 4 clauses of the definition of murder contained in section 300. Full stop. If the answer to this question is in the negative, the offense would be culpable homicide not amounting to murder, punishable under the first or the second part of section 304, depending respectively on whether the second or the third clause of section 299 is applicable. Full stop. If this question is found in the positive, then the offense would be under section 300 IPC, punishable under section 302 IPC. Full stop. If this question is found in the positive, but the case comes within any of the exceptions enumerated in section 300, the offense would still be culpable homicide not amounting to murder, punishable under the first part of section 304, Penal Code. Para. The Honorable Supreme Court in Birsa Singh versus State of Punjab, reported in AIR 1958 SC 465, has explained the meaning and scope of clause thirdly in the following words. Para 18 of A to A. Para. Therefore, according to the rule laid down in Birsa Singh's case, comma, even if the intention of accused was limited to the infliction of a bodily injury sufficient to cause death in the ordinary course of nature and did not extend to the intention of causing death, the offense would be murder. It is also apposite to refer. In this connection, it is also apposite to refer to illustration C appended to section 300 from IPC. Which reads as under clause C 300. Having regard to the nature of injuries inflicted, bodily injuries inflicted upon the deceased, as emerged from the postmortem examination report, EXT4, the date of the disease clearly comes within the scope and ambit of section 300, IPC, punishable which is punishable under section 302, IPC. Full stop. The eyewitnesses accounts have, from the eyewitnesses account, it has clearly emerged that the accused prior to or accused while before starting the shouting at the entrance and entrance area of the house of the deceased was armed with a dagger which was seized from a place near the place of occurrence, provide seizure list, EFD3 on 14/10/2017 in presence of witnesses. Full stop. The factum of seizure of the dagger in presence of witnesses was not seriously disputed by the defense during the cross-examination of the witnesses. There's this side. Full stop. The dagger, comma, seized by EXT3 seizure list, comma, was a 15 inches long dagger fitted to a handle made of cane. Full stop. The iron portion of the dagger was about 15 inches long, while the handle portion was about 5 inches long. Full stop. It has not emerged from the evidence of, it has neither emerged from the evidence, materials for evidence on record, nor it is the case of the defense that there was any grave and sudden provocation from the end of the disease full stop. Or there was a full stop. From the fact that the accused was armed with a dagger which he had used as the weapon of assault, comma, it cannot be inferred that there was no premeditation. Full stop. Considering the fact that the deceased had sustained a number of penetrating wounds on various parts of the body, comma, on various vital parts of the body, it is difficult to reach a view that the accused has not taken any undue advantage of the situation or not acted in a cruel manner. Full stop. At the time of the incident, comma, the disease was evidently unarmed and he reached the place of occurrence in response to the situation created by the accused at the entrance area of his house. Thus, we are of the considered view that the case does not come within any of the exceptions of section 300 of the Penal Code, comma, meaning thereby, comma, the offense committed by the accused is murder, first of para. Though a submission is made on behalf of the appellant, accused appellant, to the effect that at the time of the incident, there was darkness. Dona light. And there was inconsistency as regards the exact time of occurrence of the incident. Full stop. এটা আমার জিজ্ঞেস ছিল after 7 p.m. plus PLUS stroke minus MINUS 1 hour. Full stop. On the other hand, comma, the learned additional public prosecutor has submitted that the occurrence took place in the month of October. No, in a village area. And people in the rural area do not are not the people in the rural area generally suggest the approximate time. Full stop. But there were no inconsistencies in the testimonies of the vital witnesses on material points. In such view of the matter, comma, a minor variation as regards the time of occurrence cannot be a ground to disbelieve the testimonies of the prosecution witnesses, comma, which were otherwise inconsistent, otherwise consistent throughout. Full stop. it has observed in Sahabuddin and another versus State of Assam, reported in 2000, Supra. That every variation, no, no, in Sahabuddin, Supra, it was contended that the testimonies of the witnesses could not be relied upon. Two of the witnesses could not be relied upon as they mentioned different time of occurrence of the incident. Full stop. It has been held therein, it has been observed therein that it is a plausible fact that there could be some variations in the statement of witnesses with respect to a particular incident. Full stop. In the every variation or immaterial contradiction cannot provide advantage to the accused. Full stop. As it is a settled principle of law that while appreciating the evidence, the court must examine the evidence in its entirety upon reading the statement of a witness as a whole. And if the court finds the statement to be truthful and worthy of credence, then every variation or discrepancy, particularly which is immaterial and does not affect the root of the case of the prosecution, would be of no consequence. Full stop. In Kundappa Yankara Pujari Supra, it has been observed that certain discrepancies in mentioning the time of the incident cannot be a ground to disbelieve the statements of the witnesses. If the difference is about 1 hour, as the villagers generally suggest the approximate time. Another contention raised by the learned amicus is to the effect that is as regard is with regard to identification of the assailant as the prosecution witnesses as PW1 comma PW4. PW6 and PW9 had deposed that it was dark when the incident had occurred. Post. As per PW1, comma, the entrance area no, the place of occurrence was lit by street light. Full stop. Though it was winter season, the occurrence took place in the winter season, and there was no fog. Full stop. PW4 stated that at night, command of passes from the entrance gate to the house of the deceased used to remain dark, and there was no electric light at the place of occurrence. First one. As per the version of PW6, comma, at the time of occurrence, comma, it was dark when the incident took place. Full stop. At that time, comma, faces of persons could not be recognized without the use of a torchlight. PW9 had deposed in a similar manner like PW6.
Yeah.
Witnesses were inhabitants of the same village residing together for for a number of years. Full stop. It has emerged from the it has clearly emerged that one was known to the other. Identification of a person in darkness in some cases may not be difficult if a person is acquainted to another for long years, from the manner of speech, gait, and voice. Full stop. A a claim of a witness that he had identified the culprit during the commission of the crime, has to be examined by the court with reference to the circumstances of a particular case. Huh? First. The prosecution witnesses dash PW1 and PW4 who were the first ones, FIRST, ONES, first ones to reach the place of occurrence, had testified to the fact that they came to know that the accused was at their entrance gate, from the shouting made by the accused. asking the deceased, hurling abuses at the deceased, who in response to such shouting, went near the accused. Full stop. Both PW1 and PW4 had testified that they became aware about the presence of the accused from the voice of the accused only, as accused was found shouting at their entrance gate. Full stop. In this connection, full stop. As the said to prosecution witnesses, as well as PW6 and PW9, were well acquainted with the accused being their close neighbor, it is difficult to accept the contention of the appellant that the accused would not be, it would be impossible for these prosecution witnesses to recognize the voice of the accused. Full stop. আগরটো লিখিব আগৰ পইণ্টটো আগৰ পইণ্টটো It is not the case of the defense that the night was a moonless night. Full stop. One may refer to the observation made by the Honorable Supreme Court of India in Ram Gulam Chaudhary versus State of Bihar, reported in 2001, 8 SCC 311. Where a contention was raised as regards identification of accused at night. Where the occurrence took place in a rural area. It is therein, it is observed that the visual capacity of urban people who are acclimatized to lamps is not the standard to be applied to villagers whose optical potency is attuned to lesser lights. Most of the visibility of villagers is conditioned to such lights, lesser lights. Hence, it would be quite possible for them to identify man and matters in such light. As the assailants were from the same village, were known to the witnesses, the assailants, it is possible for the witnesses to identify the assailants in lesser lights also. One more. Uh, the evidence of the eyewitnesses has also found corroboration from the testimonies of PW2 and PW5 as well. Full stop. PW2 deposed, testified that when at about 5-00/6-00 PM, he was going to the matrimonial house of her daughter, he came across the accused on the road and he found the accused holding a dagger in his hands. Full stop. Before the, during, in his testimony given before the court, PW2 identified the dagger, exhibited as MET EXT1, as the one which the accused was holding on the date of occurrence, as seen by him. PW2 was not even confronted on that aspect by the defense during his cross-examination. Full stop. PW5 had testified to the fact that during the daytime on the date of occurrence, he met the accused and the accused showed him a dagger. Full stop. The accused further told him that he was going to do something with it. Full stop. He had met the accused at 7:30 PM. He had met the accused at 7:30 PM on that date of occurrence. PW5 was also not confronted by the defense on the said aspect when he was cross-examined. Full stop. Such testimony is the testimonies of these two witnesses. As regards uh, the fact that the accused was armed with a dagger prior to the incident is significant. From the standpoint of the principle contained in Section 6 of the Evidence Act 1872. Prior to the incident and his statement that he would do something with that dagger before PW5 are significant. The significant so and so. The essence of the doctrine of res judicata enshrined in Section 6 of the Evidence Act is that a fact which, though not in issue, is so connected with the fact in issue, has to form part of the same transaction, that it becomes relevant by itself, full stop. A conduct of the accused which do not in issue. It's so connected with affecting the part. Whether they occurred at the same time and place or at different times and places. A conduct of the accused. After লিখি রাখিব পিছত সোমাই দিম as the three eyewitnesses come up, PW1, PW4 and PW9 were inmates of the house and the wife and sons of the deceased, their presence at or near the place of occurrence were quite natural, and no doubt can be raised. Another full stop, quite nature. In view of the discussions made, and for the regions mentioned therein, comma, we are of the unhesitating view that there is no good and sufficient reason to depart from the view findings reached by the learned trial court. Resultantly, comma, the judgment and order of conviction and sentence passed by learned trial court is affirmed. Full stop. As a consequence, comma, the instant criminal appeal fails. The completion reason.
1 lakh lordship it was
Ah.
awarded. Can it be enhanced, my lord? Because under 2012 scheme, it was minimum 12 lakhs. If the age of the victim is 50 to 60.
Scheme paid by the government.
No, it was given, but can it be enhanced, my lord? 1 lakh has been awarded. As part the scheme, it was 2000, in 2012,
Ah.
it was 2 lakhs. If the age of the victim is above 40 years and up to 60 years, he was 54 years.
Notwithstanding the direction made by the learned trial court as regards payment of compensation of rupees 1 lakh to the victim wife of the deceased. It is observed that the District Legal Service of Authority, Jurisdictional District Services Authority, District Legal Services Authority, on an application made. Is to award compensation to the victim wife shall consider awarding compensation to the victim wife as per the ex then prevailing or as per the when it was
2019, it was amended. I don't have.
when the
that
judgment
information.
2019
2021, no?
no judgment is 2019
1921. Oh, 19.
as per the then
1990.
applicable
Yes, ma'am.
victim compensation scheme framed under section 357A of the
CRPC.
CI code. Full stop. And next we appreciate the so and so contribution M. Dot as an amicus assistance. So as a result, appeal fails. Right.
Obliged.
A copy of this order is to be communicated to the jurisdictional legal services authority. Post of next, the records of the learned trial court are to be sent back forthwith. Yes, anything more?
My lord, in this case, I just like to read from one particular which I submitted before lordships. This is that Mukarrab versus State of UP. Of course, as a lordship is noted, factors of when the age.
For that, we'll just have a
Lordship,
synopsis from you.
Lordship, what has happened is that
Eyewitness,
there was no eyewitness.
circumstantial.
Three principles, Lordship. One is that circumstantial evidence. Another one is extra judicial confession. And third is last seen theory. So these are the three, based on these three principles, this appellant has been convicted under 302. So prosecution story, as far as prosecution story is concerned, Your Lordship, what has happened is that on 20, I'll just give the date also. The incident happened in 2014, Your Lordship, 19/10/2014 at 9 p.m. It was alleged that this appellant has killed his wife inside his house by hitting her on her head as well as face. But there was no eyewitness there, though there were people like his family members were present, father, mother, sister, brother, all these people were present, but he killed his wife.
Let us see the postmortem examination report.
Yes, Lordship. Postmortem examination report, Lordship will find at page 68. Is your Lordship got it? Page 68.
Postmortem was done on the next day,
Yes, Lordship, on 20th.
9 a.m. morning.
Correct, Lordship. So page 69, Lordship will find the wounds and all. All along, 3 injuries have been stated here.
There was head injury,
Yes.
There was, yes, there was a,
anti-mortem,
correct,
blunt,
correct,
homicidal.
correct. One more thing, Lordship.
Doctor was examined as.
Doctor was examined. Lordship, one more thing, Lordship, I would like your Lordship to kindly have Lordship notice. Page 71, Lordship. Page 71.
Yes.
Page 71, Lordship, abdomen. Here, Lordship, stomach and its contents. Healthy, first, contain fluidy matter without any characteristic odor.
What does it mean?
It means that there is some fluid there, but it doesn't have that characteristic odor. Usually, generally, that odor is not there. Some fluid is there, but what I'm submitting here also, this fluid was not examined. It was not sent for it because this story of defense story is that like
Okay,
presumption of
okay, we have marked that portion.
yes,
We'll see difference when we'll hear in detail.
correct.
What is the doctor?
Doctor is at page
Page 19.
19.
Yes.
No cross-examination basically.
no cross-examination, Lordship. I would like your Lordship to see a couple of things only.
No, doctor was not cross-examined thoroughly
Not totally.
with regard to odor and all.
Not, Lordship. It was not done. But one thing, Lordship, I would just like your Lordship to point out the opinion also. That Lordship can have a look later on also, but like this page 21, the opinion part,
Opinion of whom?
doctor.
Page 20.
It is already there in 73.
Yes.
73 is there.
73 also is there. Well, I'm sorry that
That is what he has, I think. Same thing.
Yes.
no, Lordship, I mean, there is one thing. Page 73, Lordship, he says the death was due to coma as a result of head injury. All injuries were antemortem caused by blunt weapon. So here also, Lordship, this all injuries were done by the blunt weapon. So blunt weapon. So blunt, there was no weapon recovered from the crime scene.
It's one
That's what I just want.
of the maybe weaknesses.
Yes, Lordship.
Let us see. What is his version in 330?
Lordship. It's page 30 onwards.
Yes.
Question number 5, page 30.
So that is the defense case.
Yes, basically
That
that,
he
Lordship.
had fallen on the ground
Right,
and sustained the injury.
correct, Lordship.
Another plea was that she consumed poison.
Correct, Lordship. These two are the pleas.
And where you were apprehended?
I was there itself, Lordship, in the house.
Itself. Who is the complainant?
Complainant is the brother of the victim.
Others.
Page 9.
It disturbs me, like if you prompt it. It disturbs me if you prompt it,
sorry,
like let
just-
me submit, then you can do it.
That's all.
Page 4 is the FIR, Lordship. Page 4 is the FIR.
Sounds to think it is ill. 3 months pregnant. 3 months pregnant. It will be.
Was the victim pregnant at the time of?
She was not.
No.
She was not. That was the medical report.
Price.
Lordship, item number 5, Lordship, I'm there. I'm not prepared for that matter or some other dealers.
It is leftover. Yes, Mr. Kolda. You are in item 7. You are outside.
Lordship.
Then be outside.
The
Okay.
petitioners, my lord. They were appointed as LDA in the office of the district judge, Kamrup Metro, my lord. Appointment letter, lordship will find annexure A. Page
How
27 of
many?
my
3
lord,
petitioners.
of the writ petition, my lord.
3. 3
Annexure A.
petitioners.
3 petitioners are there. They were appointed as LDA, my lord. Annexure A, page 27, appointment letter.
Where are they?
My lord, petition
Serial
number
number?
1, serial number 13, Duty Narayan Gogoi. Petition number 2, serial number
One.
9, Ankita Hazarika. And petition number 3, my lord, Madhusmita.
1
Mao.
minute, 1 minute. District Judge Kamrup.
Kamrup, my lord. Order date 4/3/2014.
Yes.
They have joined, my lord, on 6/3/2014, my lord. Both three,
6-3.
6/3, my lord,
All.
all three. 6/3/2014, they joined, my lord.
Hmm. 6/3/2014.
Thereafter, gradation list was published, my lord. Annexure B,
One.
page 31, lord. 2015 gradation list, my lord. This is. They have joined in 2014. Page 31 starts, my lord. Name of the petitioner appeared at serial number 41, 42, 43,
41.
page 32 of the rate petition. Next gradation list was published in 2016, my lord, Annexure C.
1 minute, 1 minute. So your opponent is spot number 6, 7, 8, and 9. Where are they?
My lord, in this gradation list,
Okay, let us see the appointment order. They were of the same day appointee,
no.
Huh?
No, they were not same day appointed.
not same day appointee.
Yes.
Earlier or later?
Later. Their appointment, my lord,
Okay. 1 minute. Yes.
2016, my lord, gradation list.
Now, where are their appointment orders?
Appointments are there in the affidavit, my lord,
In the affidavit.
in the affidavit.
Let us see their appointment.
My lord, lordship will find in the joining, date of joining in the gradation list.
Which one? This gradation list.
Annexure C,
This one itself, page 31.
33 page, lordship will find. Page 33.
What are their names?
Annexure B, this is my lord, gradation list of
What are
2015.
their names?
49. Sandra.
40. Respond number 6 is.
50,
Respond number 6 is.
50. And anemic, that's. And 7 is 49.
Soyan Rajkumar.
This is lady, my lord, Srimati.
Soyan Rajkumar is lady.
Lady.
Onkar Judit Dev. Where is Onkar Judit?
They are not there.
Huh?
They are not in this, my lord. They have joined in 2018. Therefore, their name appeared in 2019 garrison list.
What is DOR in the gradation list? Or date of retirement?
Date of retirement.
Date of joining. Date of joining.
Date of appointment is not there, my lord. Actually, there should be a column for date of appointment. That is not there.
Date of joining is there.
Date of joining is there. Date of birth is there and date of retirement.
Yes,
As per page 33, my lord,
is 33.
gradation list of 2015, my lord.
Hmm,
My lord, their date of joining
it's
has,
2015.
yes, this is 2015. 29, 5/15, this signature is.
Hmm. Yes,
Page 33, my lord. Private respondent 6 and 7, my lord, their date of joining has been shown as, my lord, 7 shown as 23/6/2014 and 6 has been shown as 28/7/2014. Much later than my lord, the petitioner.
yes,
Then 2016, my lord, gradation list.
Hmm.
Their serial number 37, page 34, my lord. 37, 38, 39.
37 is petitioner,
Petitioner number 3, my lord, 37 is.
then 38,
38 is petition number 1. And 39 is petition number 2, my lord.
yes, yes.
2016, my lord, gradation list.
Where are their names, the respondent? The respondent name are there?
47, 40, page 36, lordship will find.
Foreign Rajkumar.
47 and 48. This is 2016 gradation list. Page 36, my lord.
Yes,
The impugned gradation list start from 2017, my lord. 2017 gradation list, my lords. The name of petitioners has been shown as 42, 43, and 45, my lord.
1 inch.
42, 43, 44, my lord. Sorry.
Yes,
And respondent number 6 and 7 has been shown, my lord. As 37 is, my lord, Charan Raspa, respondent number 7. And Animek, respondent number 6, my lord, is 39. Page 39, lord. This is, they have been placed above the petitioners. my lord.
yes,
We have filed then objection before the Honorable District Judge, my lord.
Hmm.
Then one reminder also there. There is a set of rule. Lordship will find an extra act, page 44, it starts, my lord. Page 52, Lordship, the relevant portion, the seniority. Page 52. In lower division cadre, the seniority shall be according to the date of appointment. If the person join the appointment within 15 days of the receipt of the order of the appointment, provided that in case of a person prevented from joining within the said period of 15 days by circumstances of a public nature or a reason beyond his control, the appointing authority may extend it for a further period of 15 days. If the period is not extended, his seniority shall be determined in accordance with the date of joining. When, however, more than one person are appointed on the same day, their inter-seniority shall be determined according to their position in the merit list prepared by the district and session judge. My lord, if more than one person is appointed in the same day, then their seniority will be determined as per merit position. Otherwise, merit has no relevancy in case of seniority, my lord. Then 2018, my lord, gradation list also prepared, my lord.
Yes.
2018, my lord, gradation list, last page 55. This is the type copy. Page 57, lordship will find
57.
57. 2018 gradation list.
Petitioner number 1, where he is?
Petition number 1 is in 41.
41. Petition number 2,
39,
petition number 3,
340.
and respond number
Respondent number 6, my lord. Anime 36, above the petitioners.
6. And
Respondent number 7, Sion 34.
now in this gradation list, the other 2 respondents have come in.
No. Till that they have not joined this establishment. My lord. They have joined this establishment in the year 2018. So their name came in the 2019 gradation list.
Okay.
In 2018, my lord, on the same day when the gradation list was published, on the same day promotion order was issued, my lord. Page 65, annexure G1. Promoting respondent number 7 and 6, my lord. 6 and 7, my lord. Last one, Onimake. Page 65, last. This is the order of 25/5/2018, my lord. Gradation list was also published into 25/5/2018. Page 65, last one is.
Yes.
Page 65, last one is promotion of respondent number 6, my lord, Onimake. Onimake Das, LD assistant of the establishment of the undersigned currently working as establishment assistant in the office of the undersigned is promoted to UDA with effect from 23/5/2018. Then, my lord, just before one, my lord,
Hmm.
Sayan Raspa.
Yes.
Srimati Sayan Raspa, LD assistant of the establishment of the undersigned currently working as criminal assistant in the office of the undersigned is promoted to UDA assistant with effect from 23/5/2018. They were promoted, my lord,
Hmm.
though they have joined much later than they asked, my lord. This is impute promotion order. Then we have filed the appeal
Hmm.
before the government, my lord, judicial department.
Okay, let us read that order.
Appellate order.
Hmm. Who has passed this order? Order in appeal.
Order in appeal 88, my lord. This is passed by our High Court, my lord. Vigilance.
Hmm?
Registry vigilance. my lord.
Vigilance. Okay, let us read.
Seen the appeal memo filed by the appellant Jyotinarayan Gogoi, lower division assistant in the establishment of district and session judge, Kamrup Metro, under Guwahati, under section 13 of Assam District and Session Judge Establishment Ministerial Service Rule 1987. Seeking the following relief: to set aside gradation list dated 13/6/2017, 25/5/2018 in the establishment of district and session judge Kamrup, as well as the promotion order dated 25/5/2018. This is our, my lord. From the material on record, it seems that appellant was appointed as lower division assistant LDA in the establishment of district and session judge Kamrup at Guwahati by so and so 14/3/2014, issued by the district and session judge Kamrup Metro at Guwahati, district and session judge. In the order of 4/3/2014, appellant was placed as serial number 13. He joined in 6/3/2014. Out of the 15 appointed, 3 did not join and 1 resigned from service. The remaining 12 had joined service between 6 and 13 months. In the gradation list for the year 2015, appellant was placed as serial number 42. In the gradation list for the year 2016, appellant was placed at serial number 38. Objection was raised by some of the employees, such as Saurabh Kumar Saikia, Manoranjan Kolita, and few others, who contended that in the selection process, they were placed above the appellant in order of merit. They had joined service within 15 days from the date of appointment. Therefore, they should have been placed before the appellant in the gradation list. Since the concerned employee had joined the service within 15 days of appointment, their seniority position should be as per Rule 12(1) of the service rule. On receipt of the objection, a meeting of the selection promotion committee was held on 3/7/2017. It was decided to scrutinize the service record of the concerned employee. Thereafter, gradation lists were published on 13/6/2017 and subsequent on 25/5/2018, whereby seniority position of the appellant was pushed down to serial number 41 below Srimati Ankita Hazarika and Madhusmita Mount. This petition number 2 and 3. Subsequently, as per resolution of the selection and promotion committee dated 23/5/2018, order dated 25/5/2018 was issued by the district and
Madam Bormon.
Yes.
Here,
my lord, they have not made a single, my lord.
come to page 67. This is your appeal.
Yes,
Now, in the appeal, this is only one of the petitioners had made the appeal
filed the
or
appeal.
all?
no, filed the appeal by one of them.
One only.
One.
This is petitioner number 1,
One.
right?
Yeah.
Petitioner number 1 says, and he included a number of other employees, his co-employees,
my lord.
out of that, Onimesh Das was one
Shayan was also there.
and Soyan
Yes.
was also there. Okay. So why then you have brought this Onkar Jyoti and Sandeep Soikia?
My lord, they have been later, they have joined here by transfer in 2018 and they have been placed before above us. my lord.
No, whether their dates of appointments, original date of appointment were earlier or
No.
no?
In the affidavit, date of appointment has not been disclosed, but they have said that they all joined within 15 days from date of appointment.
Okay, let us see the appeal order once again. The appellate order.
Appellate order. My lord, from the third,
Mr. Sharma, Mr. Das,
Yes.
just had a glance, cursory glance
Yes, sir.
on the rules.
Yes.
Evidently, the gradation list is prepared by the district and session judge.
Yes, sir.
I think it has this rules provided for any preparation of gradation list.
No,
Gradation
it
list.
says,
Rule 9 says, same shall be approved by the district and session judge.
yes,
Rule 9 says.
yes,
Now, any appeal is to be preferred from the order of the district and session judge to the secretary,
secretary,
judicial department.
judicial department.
Now, why the judicial department has forwarded the appeal to the registrar general for disposal? Say, for example, by page 86. They have preferred the appeal before the Secretary Judicial, apparently, page 67. MS Burman will
Yes,
just start. This is an appeal apparently under rule section 13 or rule 13. It should have been rule 13. Page 67 appeal. Right?
yes, ma'am.
And rule 13 says it should be before the judicial department,
Government of Assam.
government of Assam. Now, page 86. See the content. And 87 also. We don't know who has, there is no sign in the order in appeal, page 88. Right, they have to come to page 91.
I have seen, my lord. Register of Vigilance issued a
I
communication.
am to inform you, so instance, file an appeal. We need to forward to the Honorable High Court seeking the following relief. On consideration, the Honorable High Court has been pleased to reject the appeal as the same is found devoid of merit. Register of Vigilance. How, the
Perhaps-
rule has been amended?
No. Perhaps, my lord, they should have taken the input from the registry or instruction, whatever the opinion, because it was a recruitment, centralized recruitment conducted by the registry. And thereafter, they should have passed the order, judicial department.
Because rules are apparently framed by the state government.
Yes, my lord. The order should have been by
Is
the
in
judicial
maybe
department.
consultation with the High Court,
Yes,
but apparently they are under the, this is under the proviso to Rule 309 perhaps,
yes, my lord.
right?
Yes,
Otherwise, the Guwahati High Court rules is under the Rule 229,
229.
say Article 229.
Sorry, yes, Article.
But this is 1987 rules are under the proviso
30.
to 307. As per the rules, which is in constitutional character,
Yes.
the power to decide the appeal
Is
is
with the-
vested in the judicial department.
True.
So how this has come?
That's, my lord, that's also I have.
That
also
they have
seen-
the authority and jurisdiction to decide an appeal.
And how this
We come by
appeal,
one
Oh,
hour.
yes.
how
Have
this,
patience.
how this appeal, my lord, was communicated to the petitioner, this appeal order at page 88.
Right.
So,
Page 86 first, it
Yes.
indicates that the
First 86.
judicial department has forwarded the
To the
appeal
reg-
memo to the High
Reg-
Court
yes,
to take necessary action from your ends.
it is,
And a High Court has, or registered vigilance, suppose, has assumed jurisdiction to decide the appeal. And apparently, C87,
yes,
that this is an annexer to page 86. Now, this is 88, order in appeal. We don't know who has passed this order, right? But from page 91, it appears that Honorable High Court has been pleased to reject the appeal. Right?
normally, my lord, this type of appeal, page 88, normally this type of order is not passed, my lord. If some order is passed, signature will be there.
No, so but,
That's true.
are you aware of the stand as regards your stand as regards page 88? No, this is just a confusion which has
true,
arisen in
true.
my mind, so I have asked you.
Lordship is correct, my lord. But page 91 on the other hand says, this is by register vigilance.
It is signed by registered vigilance.
Yes,
So apparently it is by disposal of appeal by from the end of the High Court.
end of the.
We don't know who has passed this order,
Yes,
but it seems that it is from the High Court. Order in appeal has been passed by the
by
High
the
Court.
High Court.
And the register vigilance is somewhat silent who had passed the order. He has simply said Honorable High Court
Yes,
in bold. Right?
yes,
And copy was sent for information. Okay. We'll jot down the facts, then I will find out. Okay, let us come to page 93. In the meantime, find out what is there.
My lord,
What is 93?
my lordship, one thing, my lord. 90, page 90, lordship, may kindly go. Page 90.
I have seen it, neither here nor there.
They have not,
Neither here nor there.
they have not said anything. They said only that they.
Because you have made few of the parties as respondents.
Yes.
That your inter se seniority should be determined vis-a-vis
But this
those
person-
persons. So that was not dealt with.
And the promotion also not dealt with.
Simply your position,
Above Ankita and
Ankita Hazarika and Madhu Smita
Smita.
Mott,
petitioner.
whether
number
they were
20.
appellants,
Yes,
they filed appeals.
yes.
No, no,
This,
they are
they,
petition.
they were not appellant, but read petition there.
Huh?
In the read petition there, petitioner.
They are petition. No, no,
They-
there are few things I want to know. This appeal you
was
have
filed by
annexed.
petitioner.
What is the relevant paragraph? Please come to the relating to annexer one appeal, oh sorry, annexer annexer H appeal.
Annexa H is the appeal, my lord.
One more thing, Mr. Das, which is point apparent that paragraph 11 says only petition number 1 preferred the appeal.
Yes,
Now, in the ordering appeal, the appellate authority commented on the other two petitioners also. Uh, so yeah. Where are the appointment orders of respondent number 6 and respondent number 7?
my lord, it is in the affidavit.
Huh?
It is in the affidavit filed by the,
Let us go there. Yes. Both have filed separate affidavit or what?
no, my lord, 1, 2, 3, and 5, my lord. The Honorable High Court and the session judge has filed this.
1 minute. Onimes Das has filed an affidavit.
Yes, animation six.
Let us see his affidavit annexer.
High Court affidavit and appointment letters are, my lord.
There is list of posting.
Seven, my lord. Respondent number 7, my lord. Page 1,
Respondent number 6. Onimes Das.
6 appointment letter, my lord. 121 page, my lord.
1 minute. District wise posting. Come to his affidavit and annexer 1 there too.
High Court has filed, my lord, a nice affidavit, my lord,
We'll
detailed, my lord.
see it. Okay, we'll see.
All things are there, my lord.
We'll see to that. Yes, High Court affidavit.
High Court affidavit also. High Court affidavit, Lordship, Annexa R1, page 123 is the advertisement. Here, minor clause 6,
Clause
6, my lord, at page 127. One candidate will be allowed to submit one application, only indicating the preference for the post in the district one. The candidate has to prefer the district where they want to be posted, my lord. Well, C, Lordship will find the district indicated in the application form by a candidate will be treated as preference only, and depending on the agency, Guwahati High Court may appoint, transfer, select candidate to any subordinate court establishment within the state of Assam. Guwahati High Court has a right, my lord. Then final Z, Lordship, final merit list will be prepared district-wise as decided by the Guwahati High Court. Preference of selected candidate with regard to their place of posted indicated in the respective application forms may be considered depending on the candidate's position on the merit list. Well, accordingly, the merit list has been prepared, madam.
Okay, let us examine there the position of this petitioner and the respondent.
Position of petitioner, my lord, it is in the paragraph.
No, in the list. List
List.
is there and when
A
why?
list is there, my lord,
Ah,
but in
Let
paragraph,
us go to the list.
yes. List, my lord, 50 Shayan Raswan,
50.
50, page 32,
He is what? Respondent?
7. Merit position 60. Onimek
50.
Das, 60, 60. This is respondent number 6, my lord.
He is respondent number 6.
6.
Yes. And the other two?
Other two, 113 at page 133, next page. Omkar
He is
Juti,
respondent number
this is 8.
8.
8.
Yes.
And 119, Sandeep Saikya, this is 9. Their merit position.
And what about the petition?
Petitioners, my lord, it is in page 134, OBC. Reserve category,
Yes.
below, my lord. Reserve category, list for reserve category candidate, SC, ST, STP, my lord, 6, Ankita. Petitioner number 2,
Petition number 2.
Ankita. Then 8, Madhusmita, petitioner number 3. And 19, my lord. Petitioner number 1. Jituna and Google. This is their merit position, madam. Then lordship will find their place of posting. Notification dated 10 January 2014, my lord, 114 page, 1141 page, my lord. Annexa R3. 141, my lord, 141.
Hmm.
157 serial, my lord, at page, my lord, 147. 157 serial, page 147, my lord.
One
57, Madhusmita Mouth, petition number 3,
57,
157.
P3.
Petitioner number 3. Then, my lord, 159,
P2. Petition number 2.
petitioner number 2.
And petition number 1.
1 is, my lord, one is at page 152. His place of posting has been shown as Udalguri. Serial number 292. Page 152.
And let us see respondent.
Respondent, my lord, Animek, my lord, respondent 6, 171, page 147. my lord.
Respondent number
6,
6.
yes.
Only yes.
Then, my lord, page 150. 253 serial number.
Yes.
150 page, my lord.
She is respondent number
7.
7. And respondent number 8.
8, my lord. 8 lordship will find page 148.
148.
Eight.
Serial number.
191.
He is respondent number 8.
8. His place of posting Karbi Anglong.
And respondent number 9.
9 Sandeep Saikya. 195. His place of posting also Karbi Anglong. Initial posting, my lord. Respondent number Respondent number 6 was posted as CBI Court, Kamrup, my lord. Initial posting. This posting, place of posting was modified, my lord,
Yes.
by the High Court.
Okay.
This is 17 February 2014, order 153.
Again, let us go to position.
Yes. Position of this is not as per merit, this is as per my lord, place of posting, my lord.
Okay.
They are apparent.
Still,
They are-
let us see.
Yes, yes.
Position of petitioners.
Ankita lordship 152, page 158.
Page 152.
Page 158, my lord.
She is petition number 2.
It is number 2, 152 serial number. Kamrup District Judge, LD. Then, my lord, Madhusmita, petition number 3, 154, just below. Then
Yes.
Jyoti Narayan Gogoi, earlier he was in Udalguri, he has been brought to
Ah.
High Court, District Judge. By High Court to District Judge, my lord. 159.
Respondents.
Animek lordship will find 159 next page.
Onimus 177.
Respondent 177, yes. He is respondent number 6, my lord.
R6.
He's-
Respondent number 6.
His place of posting has been shown as Karbi Anglong, Civil Judge, Munsif, Junior Division, LD.
Yes. Respondent number 7.
Respondent number 7, my lord, page 161. Below last 243.
Serial number?
243. She has been posted at Nagaon.
Okay, respondent number 7. Respondent number 8.
8, my lord, 2, same page, 225, my lord. Lakhipur.
Respondent number 8. Okay.
8, Sandeep Saikya, my lord, Lakhipur, STJ, same.
Serial number?
Serial number 226.
226.
Nine.
Huh?
It's only 9.
No, Omkar to 225, I to 226, Sandeep Saikya. একেলগে আছে দুইটা লক্ষীপুৰ।
8 was something.
Respondent 8, sorry. Then, my lord, there is a direction to issue appointment letters. By the Guwahati High Court. This is 2/22/2014. Then our appointment letter was issued, my lord. Annex R6, page 166, our appointment letters.
Yes.
This is, my lord, 4/3/2014, 4 March 2014. Then another notification came, my lord, 12 June 2014.
Soyan Rajkumar is respondent number?
Soyan response 7. He was re-allotted. District Judge Kamrup, my lord.
And what about the other 3?
Other 3 is not yet, my lord. His appointment letter is there, my lord.
Order, appointment order.
Yes. Other 3, my lord, Rossi will find Anime
Where?
173 page. This is respondent number 6. (36) serial number. 173 page, 36 serial number.
30.
6. Additional district of
6.
Kamrup.
His respondent number?
6.
6.
Yes. He has brought to Kamrup, my lord.
Then other 2?
Other 8 I found, 9 I did not found this my lord order. Though they have in statement, they have said by this he has been brought from Nazira, but I have not.
Soyan is respondent number?
6.
6.
Soyan is 7, my lord. Soyan is 7.
7.
7.
7.
7. Animus is 6.
And what about this respondent number?
8 I have found, my lord. Page 174.
Dated?
This notification, my lord, same notification.
1. Notification means which one?
21 July 2014. Annexa R7. Page 172.
Their respondent number? Omkar or what?
Omkar.
Where is he?
He at 7, my lord. Bokakhat, Lord Civil 5.
7.
Serial number 7, Bokakhat Omkar.
Serial number 7.
Page
170.
174.
No, your page and my page are not telling. That is why.
Oh. It's আপনারা- This is the notification of lordship verified.
Hmm?
The notification, my lord. Notification dated 21 July 2014.
21 July 2014.
14. Register administration come in charge centralized.
Oh. Where is Omkar?
Omkar, my lord. The 4th page. Lordship will find Bokakhat.
Oh, Bokakhat. Okay.
Gopur Bokakhat.
He is
Bokakhat
respond number
8.
8.
Omkar. Now lordship will get the appointment letter of respond number 7. 175.
Yes, seen. I have seen it.
Then respond number 6, my lord. 176.
Yes, I have seen it.
These two appointment letter dated 16/6 after 3 months, lordship. 16/3/2014. Our is in March. Their appointment is in June, my lord. Then this is July 24/7/2014. Much later than the petitioners.
Whatever respond number 9.
8 and 9, my lord, they are transfer order.
Yes, where is the original one?
8 transfer order, lordship will find at page 177.
That I have seen, but
9 is the next.
before transfer, there has to be appointment.
That has not annexed.
Yes, Mr.
But as per my lord,
Whether the respond number 8 and 9 has filed any affidavit?
8 and 9 not filed.
Huh?
No affidavit has been filed.
Not filed.
Not filed.
They are served or not?
Sir,
Hmm?
dusty service was done. Dusty service was done. Transfer on own request, my lord. Transfer
Who?
on own request, my lord.
Who?
My lord, these two. 8 and 9.
Where from you are saying?
My lord, page 178. The concerned employee will not be entitled to any claim TADA and the transfer are made on their request, as their transfer were made on their request. These transfer are as per their own request. The next one also there. 181. As per number 9.
Okay.
Now I have one prayer Lordship may go through the accreditation list of 2019. It is in the petition, read petition Lordship. Annexure J, page 95 of my read petition. Here, my lord, page 96.
Yes. Soyan Raskor.
Last one, 31. His
You
date of
use respond number
Sayan Raspar is respondent number, my lord, 7.
7.
96.
His
Okay.
date of joining has been shown as 23/6/2014. Date of joining. Then respondent number 6, Onimes has been shown as 28/7/2014 at serial number 33. Next page, 97.
And where are the petitioners?
My lord, in Lordship will go 96 is the Omkar, 22/7/14, date of joining.
Okay, we'll end the exercise today.
My lord,
I have
they
got-
were transferred in 2018. Their joining has been shown as 2014. The place where they have joined earlier.
Sir, last, you get the appointment orders of respond number 8 and respond number 9.
18/9, my lord.
Much obliged also.
Because we have seen only their transfer orders.
Yes, my lord. I'll
So far,
bring it.
the documents I have seen. I
Yes,
don't know.
my lord,
whether
I have
those
also,
are-
my lord, made a statement in the affidavit saying that they joined in Bokahat and other place at that point of time, but
Oh,
that
what-
order,
date.
order has not been annexed. I'll place on record.
Otherwise, the date of birth should be when the child is born.
That's true, but here,
Let us see.
yes,
Rule is
we are
very
not-
specific also. Rule is very specific.
Normally,
I'll try to.
there may be exception.
Yes,
That we don't know.
yes,
Okay, after 1 week, we don't know what is the roster.
I am,
I'm finding it very difficult.
yes,
Neither there nor here. Cannot sit for the full time in the other bench also.
yes, my lord.
Third MSP Burman. Otherwise, MS Burman, it will be before me only, so
Yes,
Yes,
there is no bar,
yes, as per
no,
Lordship.
no doubt about it, that it will be,
Lordship.
it will come back again before me.
Lordship.
I have at least gone through the facts, subject to further hearing. P. Burman, learned counsel for the petitioner, H.K. Das, learned standing counsel, here, he has. And any state counsel. And Mr. KJ Arjuna for the respond number 6 and 7. Okay, release the case. After a week, on a date to be fixed by the office.
absolutely.
Must oblige.